But right now, the overall reading is about admissions into an institution, and there are no public institutions in Alabama that have um, quotas or requirements for admissions based on ethnicity.
Earlier today, the United States Supreme Court ruled against affirmative action programs at Harvard and the University of North Carolina.
That decision, affecting university admission decisions, is expected to apply to higher education institutions all across the country.
News 19's Alexa Harley joins us now in the studio with more on this ruling and how its impact could be felt right here in Alabama.
Yeah, the Supreme Court ruled on Thursday that race-conscious admission policies, specifically at Harvard and UNC, were in violation of the Constitution. The lawsuit was brought by Asian American students who argued admission policies favored students of other races at their expense. The court's majority agreed, saying under the Equal Protection Clause, quote, race may never be used as a negative and that it may not operate as a stereotype.
There is a question about whether the details will also address admissions into particular programs at that institution. So you would have perhaps maybe an earmark for certain slots for a law program or for nursing and others.
That was the executive director of the Alabama Commission on Higher Education explaining how the ruling could affect specific programs within college institutions. As for some North Alabama universities, the ruling raises new questions.
And there are no public institutions in Alabama that have quotas or requirements for admissions based on ethnicity. The state of Alabama has provided some aid to address programs which perhaps have lower enrollment of minorities than would be expected. And so we would actually, the admission process is not impacted, but we do provide minority scholarships for particular programs. Alabama A&M Athens State has a program on getting more minority teachers.
The court decided 6-3 and 6-2 in both cases that Harvard and UNC's admission programs were in violation of the Equal Protection Clause of the 14th Amendment. Supreme Court Justice Sotomayor, one of 3 justices who dissented, said, quote, in the end, when the court speaks of a colorblind constitution, it cannot really mean it, for it is faced with a body of law that recognizes that race-conscious measures are permissible under the Equal Protection Clause. Instead, what the court actually lands on is an understanding of the Constitution that is colorblind sometimes when the court so chooses. Jim Purcell also says that for higher education in Alabama, there is a commitment to seeing that all citizens have an opportunity to be successful.